We are delighted to have the opportunity to update you on I-9 enforcement and immigration employment authorization eligibility compliance. As we get ready for the inauguration of President-elect Trump on Friday, there is no doubt that we will be entering a new era in the immigration sphere. Just this morning, when I opened my Los Angeles Times, the headline article was "Immediate Immigration Action Likely." This feature article, which I'll spend a few minutes, accurately summarizes what we anticipate will happen very, very quickly, just as soon as President-elect Trump takes office. Specifically, they talk about the fact that he will take immediate steps towards transforming the immigration system as soon as he takes office on Friday. The article talks about expect to see images on the evening news of workplace raids as Trump sends a message that he is wasting no time on his promised crackdown. The article goes on to talk about the fact that Trump will also widen the range of people singled out for deportation. For those of you old enough to remember, some time ago, we had an Attorney General by the name of Janet Reno. Janet Reno sadly passed away recently. Janet Reno was, if I remember correctly, choice number 6. The first 5 candidates, including federal judges, were disqualified based on the fact that they had hired undocumented employees. And that was a disqualifying. That alone points out exactly how widespread the practice of having hired an undocumented worker is. We haven't heard much about this under the current administration. The emphasis has moved from the high-profile worksite and factory raids to what we call desktop raids. Notices going in the mail to employers, but those have been focused very carefully into so-called sensitive industries. We are expecting to see a much broader and much higher profile with a reversion back, if that's the correct word, to some of the tactics that we saw under President Bush, and I'm referring to President Bush Jr., where there were helicopters, dogs, rifles drawn, and military-style raids on workplaces where there were undocumented workers. So this is the emphasis that we now see. There is no question that President Trump is committed to building a wall. That will no doubt be built. So to quote Trump's transition team, they have planned a, quote, very robust few weeks of executive actions on immigration. President Trump's spokesperson, Spicer, told reporters on Wednesday that he will sign 4 or 5 executive orders within hours of taking the oath of office. So we can expect to see immigration become the number one issue, or one of the number one issues, and with, quote, a stroke of the pen, Trump will also send Obama's move to protect from deportation hundreds of thousands of children brought to the country without authorization. The 740,000 DACA kids, the young kids brought to the U.S. as children who've been granted work permits, may see the possibility of their work permits not being extended. On the positive side, I do believe that we might see movement on the DREAM Act, which would give them more permanent status, but I am worried about the children with regard to DACA. When you meet these kids, when you talk to these kids, you will find that they are Boy Scouts. They look, sound, and act like typical American kids. So let's hope that they won't be rounding these kids up. They have also promised, and I quote again, Trump has hinted that the Republican-led Congress will revamp the work visa system. We're expecting to see changes to the H visa, to the L visa, and the possibility of reducing the flow of legal immigration. There is talk that they will cut the quotas. The already existing lengthy wait lines may well get even longer. Expect immigration and customs enforcement agents to raid workplaces to detain people in the U.S. without status. Agencies are preparing to counsel children who have seen their fathers and mothers handcuffed and driven away to an immigration detention center. I'm not making this up. I am quoting from today's LA Times headline article to give you some idea of what people are expecting. President Obama's deportation level dropped last year to 235,000. That's 250,000. In his first term, he was averaging approximately 400,000 a year. We can anticipate that President Trump needs to prove that he is tougher on immigration than President Obama was in his first term. So we're looking at potentially a double in the number of people. These are not statistics, folks. One person, one nanny with children who've been here for 25 years, being arrested, throwing in a prison, U.S. citizen children left without their parents. Pardon my drama, but this is what we will be seeing, in addition to building a, quote, big, beautiful wall across the entire U.S. border. Do we need to control our borders? Clearly, the majority of Americans believe that this should be done. The concern I have, of course, is if you build a 20-foot wall, will somebody build a 21-foot ladder? And on that note, folks, enough of the summary of the article. Let's go into what is it we are going to do in order to prepare. This is the slide that I had prepared. We've already seen a start of workplace raids. On January the 2nd, restaurant was hit in Buffalo. The owners, it appears, will be criminally charged. And all I can say is that what we have seen since 2009 was President Obama, 8,900 employers have had fines of approximately 100 million imposed. I'm going to say chicken feed compared to what we can expect. And the message I'm giving you today is compliance. There is no choice but to follow the law. We are not talking about new laws. I am talking about existing laws which seem to be haphazardly applied from time to time. There is no question that this administration is going to rigorously enforce the law with regard to proving that a person who is in the United States has the right to be employed. So let's get everybody ready. We have a lot of material to cover today. I probably will not be taking questions just out of respect for your time. I want to try and finish this webinar within approximately 45 minutes. If, however, you do have questions afterwards, please feel free to email me. My name is Bernard Wolfsdorf. That's Bernard, B-E-R-N-A-R-D, at wolfsdorf.com. You can see it on the bottom of your screen, the difficult spelling of my name, Bernard at wolfsdorf.com. Please feel free to email me with your questions. But the message I'm going to give right now is, number one, make sure you do your I-9s correctly. And number two, you may want to consider doing an internal audit to make sure that your existing I-9s have been updated and that you are in full compliance when the raids start. So again, moving on to the potential consequences. Employers who violate the I-9 laws, civil fines is what we've seen, criminal penalties if there is a pattern and practice of violations. So if you have a history of prior fines, and by the way, I find this with some of my big clients, that maybe they had a notice of intent to fine and a fine issued 25 years ago. Current HR are not even aware of it. And yet, of course, it's in the record, so you are subject to enhanced penalties based on past transgressions. You can be debarred from certain government contracts, which, of course, could be massively adverse to your business operations. Back pay in the instance of discrimination. And I have to mention this, under the Obama administration, the emphasis has gone almost more to the Office of Special Counsel. When President Reagan signed this law, it was anticipated that there would be discrimination against certain people as a result of this requirement to prove that you have the right to be employed in the United States prior to commencing employment. And there is no question that people often of darker color may be asked to produce documentation on the assumption that, well, if you have an accent, such as me, maybe you're a foreigner. Well, let's take this situation. I walk in, I apply for a job, I sound like a foreigner, I present a driver's license, I present a social security card that is not laminated. I present my social security card, original, unlaminated, because that's a disqualifier, and my original driver's license, and you turn to me and say, Mr. Wolfsdorf, that's very good. Could you show me your green card, please? Bingo, we got you. That is discrimination. I'm going to call 1-800 U.S. Department of Justice, Office of Special Counsel, and if you happen to be the one who discriminated against me or asked me to produce a different document, that is called over-documentation, that is discrimination. I happen to be the lawyer now that you call. I'm going to say, don't hire me. Just pay up, because it's too late. So on the one hand, you have to enforce the law. On the other hand, if you do it too diligently, and we see that all the time, if you do it too diligently, you could be in bigger trouble for discrimination. And the type of subpoenas that we see in that area are horrific. So the other one, and it's mentioned in the restaurant case that I briefly touched on, providing housing and accommodation suddenly moves into the whole concept of harboring undocumented. Harboring can be a criminal offense, is a criminal offense, and it's not unlike smuggling aliens. So please be careful, folks. Let's follow the law. Let's make sure we get it right. And by the end of this webinar, most of you will have a good understanding of how to do this correctly. This is not new. This is old. We know what's going to happen. We've seen this over time. And there's an opportunity now to get your I-9s in order, because inspection will be the order of the day. Audits will be the order of the day. Site visits will be the order of the day. This is a new era. They're coming to knock on your door. The old quiet desktop raids of the Obama administration, which was a letter in the mail, will probably continue and maybe increase. But in addition, we're going to get the made-for-TV special with the TV camera following the dogs, following the helicopters, following the ICE raids, front desk, back desk, terrified workers being taken off in handcuffs. This is the reality that we're going to continue to see. How do I know this? We've had it before. The Bush administration shut down a whole bunch of meat processing, chicken processing, and numerous other factories. Talk in the bread basket of America, in the agricultural region of Northern California, is that 85% of workers currently picking our fruit may be undocumented. So what's going to happen? Are they going to come after them? I know the workers are terrified. The agricultural lobby is in full steam. Yes, they are powerful. Will they go after agriculture as well? All I can say is when they were considering this several years ago, and I did a webinar, a writer said, one of the audience emailed me and said, it's time to start hoarding strawberries. That was a little bit funny, but the reality is we may see something happen to food prices if, in fact, there's no one to pick the fruit. I have two kids. One is 32, one's 28. I don't think if you paid them $25 an hour, they're going to pick strawberries. So that is backbreaking work that is traditionally done, unfortunately, by undocumented workers in the U.S. That will be one of the adverse consequences. Pardon my little political ranting and raving, but the question is, we have apparently 4.8 under 5% unemployment in the United States. We need agricultural workers. We need more agricultural workers. The people often doing the backbreaking work are unfortunately undocumented, looking after the young, looking after the elderly, looking after the sick. So many of them are in fact undocumented. But all I'm going to tell you is, employer, be afraid. Employer, be compliant. Okay, so this is the basic guideline used to assess civil penalties. Starts off with a notice of inspection. They come in and inspect your I-9. You then get a notice of suspect documents or notice of discrepancies. Then the violations are mentioned. You have an opportunity to correct some of them. For the substantive violations, you could get a warning notice or a notice of intent to fine. With the technical violations, there has been less effort to fine people for technical violations. By the way, there are very few things that constitute technical violations. Maybe if you forgot to dot your I and cross your T. Most of them will be subject to substantive violations for which you can expect a settlement offer, or more likely where you would end up paying a fine. If you want to challenge them, you have to go to a judge for a formal hearing. Usually it's best. Our experience is we usually negotiate the fine down. Going to court isn't an option, unless, of course, you're a federal contractor and having a rap sheet, as it were, under the Immigration Reform and Control Act. This is called IRCA, of course, the Immigration Reform and Control Act. You will potentially be disbarred from bidding on certain federal contracts. So in that case, maybe you do have to fight it. But let's get everything in order so we do not end up with a fine, with a penalty. They're coming after the employer. This is clearly the most effective way to round up undocumented, starting the sweeps, starting to go into neighborhoods, raiding homes, less effective than coming after workers in factories. And we can expect to see this happening starting next week. So the civil penalties and fines, by the way, we will send this PowerPoint out to you. There's honestly too much material in here to go through. But just to basically understand, first offense, second offense, third offense, you may think this is your first offense, but you might actually find out that it's your third offense because you're a large organization and there was a problem 20 years ago which you don't even know about. So in terms of knowingly hiring or knowingly continuing to hire, I was talking to a major client of ours where we're doing a compliance internal audit. We don't have any problems. We're just cleaning up our act. And inevitably, information comes to the employer that this individual is in fact not authorized to be employed. We have suddenly converted a relatively small issue into a knowingly continuing to hire. The minute you have knowledge that that person is undocumented, you might have only had a technical violation up to that point, but the minute you have knowledge, so not from a strategic point of view, but if 100% of your workforce are undocumented, maybe an internal audit isn't the thing you want to do, because now you're going to convert your entire workforce to knowingly continuing to hire if you don't lay them off immediately. So this is a heart-wrenching thing. Many of these people have been employed 20, 25 years. Many of them will be the best workers. Many of them will be the supervisors or the managers or even the owners of the business. Undocumented, the estimate is 11 million. I don't know what the real number is, but the bottom line is, for a first offense, you can now get up to $4,000, $4,313 each. For a third offense, that's $21,000 each. You got 10 workers. Sorry, I'm a lawyer. Pardon my math, so round it off. You got 10 workers. It's your third offense, $200,000 a pop. You got 100 workers, $2 million fine. Honestly, I have seen so many where I've reviewed 300 I-9s and half of them were bad. So depending on the industry that you're in. So we're talking about potentially hundreds of thousands, potentially millions of dollars of fines. The second fine for failing to comply with Form I-9 verification requirements, as little as 216. This is your minor technical violation, or substantive, quite frankly, is 216 up to 2,000 each. For committing or participating in document fraud, obviously more than double. So pretty snazzy fines we got here. They've recently been increased. Maybe they'll be using this money to build the wall, but they're going to be collecting millions and millions of dollars from employers who do not attend the seminar. Moving on, committing document abuse, and this is the other one that I mentioned, unlawful discrimination, from 445 to 3,500. And those of you using E-Verify, failing to notify DHS of a final non-confirmation, between 750 and 1,500. So be careful, E-Verify folks. Make sure that whoever is your designated person knows what they're doing. You cannot make mistakes in this area. Those of you using E-Verify, the government has you in the system. They can find you. They can catch you. They are watching you. I'm not saying don't use E-Verify. I'm just saying they have access. They know where you are, and they know the details because it's in their database. That's a government database, obviously. So finally, the bad one, engaging in a pattern or practice of hiring, recruiting, or referring. So you do this a lot, and you end up with 6 months in prison. Most HR managers do not want to go to jail. Most employers running a restaurant with undocumented do not want to go to jail. And there are a lot. There are a lot of restaurant owners, there are a lot of employers who have engaged in a pattern or practice of hiring, and in addition to a fine of $3,000, we're talking prison time. So this is scary stuff, folks. And I'm not even getting into the whole area of RICO and harboring and alien smuggling and everything else. Just remember, the government can throw the book at you. Unfortunately, you have to move quickly to clean up your workforce. There is going to be a shortage, but then, of course, President Obama, scratch that, new president. President Trump is going to be able to say, as he has been saying, I am creating jobs, jobs, jobs. All right? A little quote. I don't want to get into politics. Obviously, I'm getting into politics, but I was listening to a quote from somebody who voted for Trump, who had voted for Obama, and this person said, Hillary was concerned about who can use a bathroom. Trump is concerned about providing jobs. Well, apparently his message worked better, and a lot of American citizens decided they were more worried about jobs than bathrooms. I don't have a view on that. I think they're equally important, but obviously my views don't count. Let's move over to the big news. Next week, January 22, we now have the new and improved Form I-9, the so-called smart form. How smart is it? Well, it's not bad. Actually, they did a good job. I'm not Mr. Negative. How do we know which is the right form? So we Google Form I-9. The form with the revision date of 11/14/2016, November 14 on the bottom left, is the current form. Employers may continue to use the old form, which has the revision date of March 08, 2013, up until Saturday. So Saturday the 21st, let's just use the date. As of January 22, do not use the old form. You have liability for using the old form. So those of you who joined the seminar, you got your tidbit of useful information. You are going to make sure that the form that you use is dated November 14, 2016 on the bottom left-hand corner. So what are the changes to this new form? We're up to 4 pages. The employer must now certify whether they used a preparer and or translator. Big deal. If there's more than one translator used, there's an addendum and space for this. The best part about this form basically is that it does provide basic field validation, helper text, hover text, error messages, and drop-down menus. So this will decrease the common mistakes. This form is good. But remember, it still has to be printed, hand-signed, and retained. And it will not catch every error, but it's going to catch a lot of errors that we see. So it's still not a safe harbor. You are still subject to fines and penalties if you make mistakes. So get your I-9s in order. So who needs to complete an I-9? People are often confused about this one. Everybody. The CEO of the company, the CFO, the COO, the big cheese, got to do an I-9. I love this one. I always start off an audit and say, oh, by the way, do we have an I-9 on file for the president of the company? And they say, oh, no, or the other one, no, we only hire Americans. I hear all these silly stories. If you were hired on or before November 7, scratch that. If you were hired before November 7, November 6, 1986, which is a long, long time ago, 14 and 17, 31 years. Boy, this has been around a while. Did I get that right? 14 and 17, 31. Lawyers, I have to take off my shoes to count past 10. So 31 years ago, you've been working for this company for 32 years. The company's only been in existence for 30 years. Everybody has to be I-9'd. Casual domestic workers. Oh, well, yeah, my employee only comes, once a week. My nanny only comes, twice a week. That's not a casual domestic worker. That's somebody literally comes for 1 day or 2 days. Not somebody comes back every day. So sorry to put fear into your hearts or the hearts of many homemakers, working mothers. Yes, you're a target. Independent contractors. Well, what is an independent contractor? Everybody does this little, oh, he's an independent contractor. I don't control. The minute you have knowledge that person, that independent contractor is in fact undocumented, you have liability as well. The so-called Walmart case changed all of that. Walmart basically locked its cleaners up so they had control over the premises and they were held liable for those undocumented workers. The big one, of course, is you're not physically on U.S. soil. Well, yeah, okay. So, if this person is working abroad, well, then we don't I-9 them. In order to be a U.S. worker, you have to have your big toe on U.S. soil. All right, E-Verify summary. Do I recommend E-Verify or not? I recommend that you clean up your I-9s before you do E-Verify. That is before you join the federal government's database. It's an automated database linked to DHS SSA database, Social Security Administration. Make sure you've cleaned up your I-9s, not that you've dived into what I call confession arena, that you have not dialed into the confession arena by joining E-Verify before you have perfect I-9s. Otherwise, you are enshrining your I-9s in the government database. Be careful. They can see you, and they will come for you. How do I know this? They've told us. They're not shy. Electronic query submitted once I-9 is completed. Important issue. You cannot use E-Verify as a screening tool. You cannot. They don't want that. They consider that discrimination, and you can only use it for new for hire. So you can't use this to do your internal audit, run through all your workers just to make sure that they're legal or not. You cannot do that. It's not allowed. Don't break the rules. So I already mentioned the fine for failing to follow up. Follow up on your TNCs. That is where you get a hit and they failed to clear. So if you're using the E-Verify database, you need to read M775. Just Google M775 if you can't read my address. 600,000 companies have enrolled. More than 1.9 million hiring sites represented. Pretty big statistics. And in many instances, it's mandatory. So this gives you some idea. 98.94 confirmed, small percentage not confirmed. But of course, those are in the database. They've done almost 24 million e-verifications already. This is statistics just for the period October to June 2016. 23 million sounds like a lot. I don't know if that's a total amount from the beginning. More important, these are the states that have MOUs, E-Verify MOUs. You can see where you are. This shows the level of enrollment, pretty high in California, not high in some states, but we can see California, Florida, Texas, pretty high enrollment and use of E-Verify. By industry, construction, specialty trade contractors, food services. So that shows you who's using it, who's not using it. Now, this is kind of important. This shows where E-Verify is required. So let's take Colorado, for example. City, county employees and contractors. You don't have a choice if you are in one of these states. And if you have branches in different states, then you better make sure you are in compliance in regard to your workers in that particular state. So even though you decide not to be E-Verified in your home state, let's say California, you better be E-Verified in the states listed, for example, Colorado, Missouri, and there it's not only state agencies working with state agencies or contractors, but even city, county employees and contractors providing services as well. So if you get a TNC, you need to print the notice, give it to the employee. If the employee does not contest the DHS final non-confirmation, then you must terminate. If the employee contests, then you generate a referral date confirmation. You give it to the employee who you must continue to hire while you resolve the mismatch. This could actually be abused. There could, in fact, be somebody who just jumps from job to job. contesting, even though they don't have work authorization, because you have to continue to hire while they clean up the mess. It's one of the weaknesses of the system. The employee has 8 working days to contact DHS to resolve. If they don't, so no-show may terminate. You may take 2 working days for the employer to see the updated status. And of course, then if you get a final status which is negative, you must indicate if the person has been terminated. So there we have the E-Verify system. A few tips: make sure to use the full legal name. This is the problem we have with Latino names, for example, very complicated. If they're 2 last names, 2 first names, list both. If hyphenate, include the dash. Failure to do these kind of small things, name change, women get married, men get married, names change, SSA databases are not updated, social security cards often do not reflect the current name, people get divorced, go back to old names, all resulting in TNCs, spelling errors, date of birth errors, mistakes on documents. So bottom line is problems. You are recommended to include a maiden name. That can be helpful in many cases. So some of the tips that we have. So now let's go through our new I-9. There it is, sitting bright and pretty. Expires on August 31, 2019. Our new fabulous I-9 form. And this is the only one that you can use as of next week. So number 1, big mistake. Everybody thinks we have 3 days to complete it. So let's get this one straight. Section 1, employee information and verification, complete on or before the first day. Repeat, on or before the first day. By the way, it asks for U.S. Social Security number. Some people may not have one on the first day. That is not a required block, if I remember correctly, as is the employee's email address and employee's telephone number. So now, of course, people complete it, but the key point I'm making here is Section 1 must be completed on the first day. That is the section that the employee should complete, and you need to give them that form. You need to make sure that that form is signed and dated as indicated on the bottom of the form. Okay, let's move over to Section 2 of the form. This is you, the employer. You need to complete within 3 business days of the first day of work. Now, this was always confusing, but we call it the Thursday rule. Easy way to remember, Thursday. So if the person starts work Monday, they have until Thursday for you, the employer, to complete Section 2. In order to do that, you have to see original documents, not photocopies, but original documents. And the most important thing that I will teach today is that you do not tell people which documents. I've already said that. Do not ask me for my Social Security card and driver's license. Driver's license goes in list B. Social Security card goes in list C. I give you those documents, and you go and ask me for another document such as a list A, and I got you for discrimination. Section 3 is the update and re-verification section. So if you need to update a temporary work authorization extension, you can use that form. But this timing issue is where a lot of people get it wrong. And remember, if you don't do it in time, you've got a violation, and it's a substantive violation. And in many instances, you can't fix these. If you didn't act timely, how do you fix it? There's, in the middle of that form, it says employee's first date of employment. You have 3 business days. You do it on the 5th day. How do you fix that? Cross it out? Go back and amend it? Oh my gosh. Now we got fraud. Now we got trouble. So you don't do that. No whiteout, no cross out. We will go through, you put a line through the mistake. If there is one when you're correcting, you date and initial it. That is the only way to do it. No whiteout, no blackout, absolutely prohibited. So timing a really big deal, folks. Please make sure that you get that one right. Okay, common mistakes. Check one of the 4 boxes regarding status or check the wrong box. So citizen, easy. Non-citizen national, confusing. Lawful permanent resident, that's a green card holder. And remember, when you do put that in, you need to put in the number as well. Or foreign national authorized to be employed. This is where we have all the mistakes. So I mention again, the email address and the telephone number is optional. And the social security number is optional unless you're an e-verified employer. I advise employers to leave that blank. Do we want ICE calling the employee? Remember, they may arrest the employee, but it's you they're after. You're the one who gets fined. So now they have the employee's telephone number, email number. Hey, employee, I've got a deal for you. Do you want to wear a wire? Go back to the employer. Go cry on the employer's desk. Tell them how your children have no food to eat. And then they feel sorry and rehire you and we'll arrest them. Is that going to happen? Yes. How do I know it's going to happen? Because it happened last time. How often will it happen? I don't know. But will the government use employees and wire them and send them back in after they've been terminated? Now we have knowingly continuing to rehire so they can arrest the HR manager? You betcha they will. This is standard. This is ICE, Immigration and Customs Enforcement. These are the guys trained to stop drug dealers, customs enforcement, wires, automatic weapons, dogs, search and seizure, subpoenas. ICE knows how to do these, and this is what they will be using because this is what they've used in the past. Get used to it. Get your I-9s in order. Am I trying to scare you? I don't know. You make up your mind whether or not what I'm saying is accurate, but the LA Times seems to think it's accurate, and it already started last week, so I think it's going to happen. So get your I-9s in order. Now's the time to do that. Let's talk more about common mistakes. The employer doesn't sign. Signature of employee. Signature of employee. Make sure it's in there on the bottom. Make sure the date is in there. Very often we find that the A number is missing from item 3, lawful permanent resident. List of foreign passport number, if required, that is often missing as well. Item 3. Complete section 1 by first day of work. These are the sort of 4 most common issues. These are the most common issues that we see, the most common mistakes. All of them, of course, will lead to substantive liability. Citizen of the United States, the first block, list a passport number where possible. So preparer or translator, this is where a friend or relative helps translate. If the hiring manager or manager actually completes some of the information on section 1, they need to sign. So always have the foreign national complete section 1. If the hiring or HR manager helps the employee answer a question, they have to complete. So this is the new and expanded preparer or translator. Have the foreign national complete it. Do not complete section 1, employer. I'm not going to go through this. It's quite easy. I will send this out to you. This is really important. When you hire a foreign national, do not ask for a passport. Do not ask for a green card. Do not ask for a driver's license or a social security card. You print up this form, preferably my form, and you hold it up in front of the foreign national and you say, give me an original document from list A, 1, or, you see that little or sign there? That's the most important sign. Or give me a document from list B and a document from list C. So that's the single most important thing. And for somebody under the age of 18, that could be a report card. Did you know that a high school report card is an identity document for a kid? So some of this is tough. You can read the Employer Handbook, M274. It's only about 100 pages. Or you could read my webinar. One of them will work. I do recommend the Employer's Handbook. It's better. Common mistakes continued. This is the completion for the EAD, the Employment Authorization Document. That is a List A document. I believe it's the I-766 form. The EAD is not a List C document. It's a List A document. That's what, for example, the DACA kids have. It's a little card with a picture, and it goes into List A. Common mistakes continued. Employer did not complete information about document title, issuing authority, document number, and expiration date. So it's not enough to put down document title, California driver's license. You have to put down all the other information. Who issued this driver's license? The California driver's license, issuing authority. What is the document number? When does the California driver's license expire? Other problems? Photocopied the document, did not complete the form. We see that all the time. You got a violation. So complete the form, and my advice is going to be attach the document provided you have not over-documented. If you've over-documented and you attach the documents, that is a confession to over-documentation, which, as you note, had pretty heavy fines. Am I going the wrong way? Probably. Unacceptable documents, hospital birth certificates, foreign birth certificates, restricted social security card. So you can't present a social security card that says not valid without immigration work authorization. Some of the documents have been removed from the current list, which is kind of absurd. Naturalization certificate, one of the most handsome looking documents with a picture and court and all this, cannot be used as an employment authorization document. So these are common mistakes that people have. I've already referred to discrimination about 15 times. The document does not reasonably relate. Look, there's a lot of fake documents out there, folks. There's a lot of ID theft. How will you spot ID theft? You won't spot ID theft unless you are using E-Verify with a photo identification tool. So these are common mistakes that we make. Section 2, common mistakes. You keep copies of the documents for some people and not others. So people who sound foreign, you keep their documents. Americans, you don't. Bingo, we got you. The employer who signed the form was not the same person who saw the original documents. Hey, this comes up in remote hire situations quite often. The person who sees the original document is the person who completes Section 2, the verification aspect. So what other problems do we have under employer review? Employer did not list the name and address of the business. We see this all the time. The form just isn't filled out correctly. Fill in the date of hire. They used the wrong hire date. This is so important. Remember, you have to complete Section 1 within 1 day or the same day as this date. So if this date is different from the date of hire, bingo, we got you on Section 1, and then you've got the 4-day rule. So getting this hire date correct is critical. Failure to re-verify. This is the people who don't use a calendar system. Employer didn't sign, quite common. Now we get into the complicated stuff. I'm actually not going to go through all of this. This is when we start completing an I-9 for a non-immigrant, H-1B visa holder. You put in a passport, you put in an I-94. This is a List A document, not a B or C. So for foreign nationals, remember, it's a List A document. The I-94 card. So when I was young, a long time ago, we used to have the one on the left with a nice stamp. We still have the one on the far right when you get an extension of status, bottom right-hand I-94. It's attached to the form I-797. And then for the people who are traveling, you have to print this out. You have to go to CBP/I-94. So you can just Google the term CBP I-94, and then you have to print out the I-94 card. It's a printout. It's an electronic document. And hold your breath, folks. We see so many mistakes on this printout that it's almost a 20%. And here, look at this one. They issued one for Mickey Mouse, who was born in England. Everybody knows Mickey Mouse was born in America, not in England. Stop that, Bernie. All right, so that's what a visa looks like. A visa is not a work authorization. That's a travel document. That is not the document you use to complete an I-9. This is a document you use to get in any event. This visa is expired, so I don't know why we're using expired. How to complete an I-9 for somebody? I thought I just did this. Complete Block A for somebody with an ID. For OPT, F1 OPT students, people with pending green card applications, they have EADs. You fill out List A. That's kind of easy. There's the sample EAD, what I was talking about with that various different versions, employment authorization card. A new rule, by the way, that starts next week is that you can actually use the receipt for the extension of this document under the receipt rule. That's another big change starting next week because these things are supposed to be done in 90 days and they never are. So that's the story with the EAD, Employment Authorization Document. STEM OPT, STEM, Science, Technology, Engineering, Mathematics. Basically, STEM rules are foreign nationals graduating in the sciences, they get 12 months work authorization, and then they can get up to 24 months extension, provided they're working for an E-Verify employer. You need to read the instructions. I want to move fast on this right now. CPT, Curricular Practical Training. This is a difficult one. The form that you are actually using, and you notice there are 3 blocks you need to complete here. Passport, I-94, and I-20. These are tough. CPT, Curricular Practical Training. Okay, so 3 blocks on Part A. Here's the CPT notation on the back of the I-20. You all need to be document experts. There's the CVIS number in red, easy for you to sign. So J1s, also 3 documents, passport, I-94, and DS 2019. How many J1s in the United States? About 500,000. So don't be surprised. These are not rare things. When you see J1 exchange visitors, make sure that you complete all 3 blocks. Print up that I-94 card. There on your right is your form DS 2019. That needs to be included as well. Common mistakes, document abuse. I already mentioned this 3-4 times. These are problems that you as the employer could make. Request documents before hiring or during interview? No, after you've made the job offer. Specify which documents. I've mentioned that 5 times. Require more documents than are listed. We got you for discrimination. Refuse to honor acceptable documents. I show you and you say to me, that's my fake green card. I got you. And you ask to see documents listed from Section 1 attestation. That is not permissible. Not permissible at all. When the person fills out and puts in a Social Security, now I want to see your original Social Security card. You can't ask for that. They do not have to present an original Social Security card in order to be employed. Okay, over documentation, discrimination, who you're going to call, OSC 1-800, Department of Justice, we got you, thank you, goodbye. Retaliation, we're going to hit you hard. This office will probably be downgraded under President Trump, but I doubt that it'll be abolished. So watch out for the over-diligent person. Somebody who's been too good, tries to implement, panics after this thing, tries to be too rigorous, and you get hit for the other side, over discrimination. So this is a problem. Be careful. Otherwise, you're going to get zapped. Quite simple. Okay, so compliance continued. You must personally examine the original document. Even for remote hires, no webcam. You basically have to appoint an agent, a notary. Most notaries don't want to do this. This can be a problem, but remember, you cannot use Skype video. You cannot use any of those methods to certify that you have seen. The only exception is a certified copy of a birth certificate. The original birth certificate, of course, is in the Hall of Records, so you need the one with the purple stamp or blue stamp or something. That's going to be acceptable. So how does a person know if a document is real? Reasonable test. Somebody presents a social security card, it's got like 15 typos on it. It's probably a fake. How many fake documents are there out there? Millions of fake documents. Are you supposed to be a document expert? No. Are you allowed to be an idiot? No. You got to be somewhere in the middle. But you can't do this hear no evil, see no evil stuff. All right, so make sure you have a good document. Constructive knowledge. Hey, common sense. You should have known. Totality of the circumstances. Okay? You can't just use the I don't want to know approach. This has been expanded. We used to get something called a no-match letter from Social Security card that puts you on notice. Reckless, constructive knowledge, CK, reckless and wanton disregard, problem. Okay, should you copy supporting documents? My advice is yes. Copy the supporting documents, because if you want to argue you made a good faith mistake, how are you going to do that if you don't even have the documents? I insist with my clients, copy the documents. What if you haven't been doing it? We'll start today. Today is a good day to start copying your documents. So I don't want to argue. If you don't want to do it, you don't have to do it. I'm telling you should do it. Common issues, receipt rule. Oh my gosh, everybody gets confused with the receipt rule. What if the employee says, I lost my passport, I lost my green card? Can you use a receipt for a passport application, a receipt for a green card? Is that valid? So there's the receipt rule. You can only use for lost, stolen, or damaged, and it is valid for 90 days. So you have to re-verify within that period of time. So this does not work in regard to a receipt for an initial grant of employment authorization. Okay, and then the new rule starting January 17. What's the date today? 19. So that's 2 days ago, where the person has applied for the renewal of an employment authorization in the same category. So this is a renewal. They have an unexpired employment authorization document. So a copy of the unexpired employment authorization plus the receipt provides an automatic 180-day update. There's a new receipt apparently. I haven't seen it yet. Maybe it's in my front desk. But you can't do it prior to this, and you get an automatic 180-day. There's something new you learned, because this was another farewell present from Obama. We didn't get a lot, but we got a few, and this is one of them. So that is wonderful news. When you get the actual document, you line out the word receipt. So this is how you complete the I-9 for the receipt rule. You line out the word receipt and the old document number, and you insert the number from the document now presented with the expiration date, and you date and initial the change. No whiteout, no blackout. No whiteout, no blackout. Did I get stuck? And under the receipt rule, you then delete the word receipt, and you put in the correct updated information when the original document comes in. So there we have it. Form I-94, temporary I-551 stamp, and a photograph of the individual. If you lose your green card, they will give you a temporary green card stamp. Could even be on an I-94. Form I-94 containing an unexpired refugee admission stamp. In that instance, you must present acceptable documentation within 90 days of hire. But just bear in mind that people who lose their green cards and lose their documents, some of them you can accept, some of them you can't. It is very narrow. The receipt rule is narrow. Oh, I don't have my passport. I applied for a replacement. The receipt rule is narrow and limited only to these situations. This gets a whole lot more complicated. AC-21 portability, if you have an H1 and you transfer to another, in this instance, the receipt of the H1 is an acceptable document. Gap cap closing, the I-20, non-immigrant extensions, the 240-day rule, the receipts can be used in this instance, and you have to complete in a very specific way. You want to look at this slide. Employee completes work authorization section 1, alien authorized to work until, well, we don't have a date because it hasn't been approved, so we put N/A. Employer completes section 2, list A block with unexpired passport, and I-94 showing the H-1B status with employer A, and then you write the word AC-21 and the date the I-129 was submitted to USCIS in the margin of the form. How easy is this? Turn your head over to the left, twist it. Don't sue me if you get neck problem. But you see what we wrote there? AC-21, you put in the date, you put the date the H-1B is submitted, and boy, isn't this easy. This is so easy. We all knew this, didn't we? You know what? If you didn't attend the webinar, you did not know this, you did not get this right, you are subject to a fine. We're coming to collect your money. We is called ICE, Immigration and Customs Enforcement. 100 million collected in the last Obama administration. My speculation is many hundreds of million collected and several HR people prosecuted. This is going to be a different ball game. How do I know this? Well, they've already started last week going after the owner of the restaurant, real two brothers with green cards in Buffalo. This stuff is real. So AC-21 portability, attach the following documents: evidence of the new H-1B petition, courier receipt. I actually prefer to have the real USCIS receipt. If you're really in a hurry, you can use the courier receipt. But what if the case doesn't get accepted? There's a mistake. Proof of the payment of the government filing fee, copy of the new I-129 form, copy of foreign nationals' unexpired passport. You can't use an expired passport. And copy of the alien's I-94 arrival card. So AC-21, once approved, you receive the original approval notice. There it is. Form I-797. And you update section 3 of the form by recording the document title, the document number, and the expiration date of the new H-1 approval notice. Gap cap for employers. Employment authorization under OPT will ordinarily end in June or July. H-1B start date is only October 1. So you have to close the gap between the end of the OPT and the start of the H-1B. This is done by the International Office of the School. And here are the documents that we use: the EAD card, what I call the 766, the new form I-20, and of course the receipt of the I-797. You don't have the approval at this point, but this is what you use to cover the period between the end of the OPT and the start of the H-1B on October 1. So intuitive, isn't it? We all knew that, didn't we? NIV extensions, non-immigrant visa extensions. This is the 240-day rule. How do you do it? You put in the 797 receipt, the file number, and then you write in the words 240-day extension, date submitted to the USCIS. So Another one. Wonderfully intuitive, isn't it? This is what you have to do when you file the H1 extension and how you have to update the I-9 and remember that you calendar it. So very complicated stuff. And then, of course, when you get the approval, you need to update Section 3, line out, initial, and date, or you can just make it easy for yourself and complete a new I-9. Re-verification. You must verify on or before the employment date. Remember, if you re-verify after the employment authorization is expired, then you are knowingly continuing to hire if the person doesn't have work authorization. So quite a big deal. Re-verification, please have a good calendaring system. Common mistakes: do not re-verify U.S. citizens, do not re-verify permanent residents, green card holders. So citizens' passport expires, citizens' green cards expires. You do not re-verify. That is not required. There is an exception if there's a temporary stamp. That is a temporary green card. Somebody just got a green card. Congratulations, happy person. You just got your green card, and it says valid for 1 year once it's endorsed. The stamp on page 19 is the endorsement that activates this immigrant visa when somebody first arrives in the United States. So this is only temporary, and it needs to be re-verified. Do not re-verify continuing employees where they have an approved paid or unpaid leave of absence. Maternity leave, for example, that's obviously an expectation the person's going to come back. Demotions, promotions, temporary layoffs, strikes, labor disputes, transfers to different office, or seasonal employment. Re-verification is not required. So you have to learn that list too. You don't re-verify that pregnant woman unless you want some trouble. Then you can do it. Break the rules. So here's the basic checklist with regard to re-verification. I'm going to pass on it. Mergers, acquisitions, or restructuring. There's no requirement to complete the new one, but if you don't re-I-9 your entire workforce, then you end up with liability. The headaches we have with this. We tell everybody before you acquire that company, maybe you need to do an audit, because it may be that you have to lay off every single one of those employees. You just bought a company, you laid off all the workers, and you just wasted a lot of money. Okay, organizing your I-9s. So important. I wanted to finish this thing early, and I'm now a few minutes over. I'll try and wrap it up in the next few minutes, but never mix your I-9s with your personnel files. Keep them separate and break them down into 3 categories. I-9s for your current employees, I-9s with expiration dates, so they need verification, and I-9s for your term. So the minute somebody is termed, take that I-9 out, put it in the term folder so that you can follow the purging rule. Now, you did mess up, so why don't you just keep that I-9 forever so you can be punished for it? Or you purge it. Don't purge after you get a notice of intent to fine or notice of intent. That's destroying federal documents, but you do want to purge if you can, and here it is. Learn this one. I can never say it because I always get confused, so just keep my chart. Print this up and put it on your wall. 3 years after the date of hire or 1 year after the date of termination, whichever is the later. So the later of 3 years from the date of hire or 1 year from the date of termination. So can you terminate before that? Can you destroy your I-9 before that? No, not unless you want trouble. So correcting mistakes and omissions, it's never too late to complete an I-9. How do you correct? I've only said this 15 times. Never delete, whiteout, or blackout. Never backdate. Ooh, backdate is the nice one. You go to jail for that one. So, folks, we did that in what I hope is record time. We actually went a few minutes over. I apologize. I hope you found this at least amusing, informative. Please reach out to us. There's my email address, Bernard@Wolfsdorf. Bernie, you scared me. I actually wasn't trying to scare you. I realize this is scary. This is not some new law for the Trump administration. This is a law that's been applied on and off. So please like us on Facebook. There's my telephone number, 1-800-VISA-LAW. There's our New York office. Reach out to us if we can help. Read your handbook. We'll probably be doing this later. This is recorded. So for those of you who liked it, found they got benefit, please let your friends know. And what am I going to say? When you need an immigration lawyer, call 1-800-VISA-LAW. Call Bernie Wolfsdorf. Boy, that sounded like a cheesy ad, but I'm just being a little silly. Thank you so much, everybody. Have a lovely day. And we're going to get through this, hopefully. And goodbye. Thank you so much.